welcome everyone. So thank you Connectability for hosting this third Wednesday of the month Neuro virtual support group. And again, this is not just for Parkinson's, but for also other neurological conditions like stroke. It is not just for the clients, but also for families and caregivers. Knowledge is power. And so the more information that we can get to help take care of our loved ones in the home, the better. So we are blessed today to have a lawyer as our special guest speaker. Mr. Brennen Boze is a lifelong Texan who moved to San Antonio at the beginning of this year. He is a graduate of the University of Texas at Austin and Baylor Law School after more than 10 years working as a litigator in Houston. Brennen shifted his focus toward assisting the elderly, disabled, and their families with estate planning, probate, and long-term care planning services. He has appeared in state and federal courts across Texas, representing individuals in crisis, small business owners, and large corporations, and brings over a decade of experience in the law offices of Carol Birch. And so we're so blessed, and we thank him for his valuable time to share his knowledge and expertise. And also, by the way, thank you AQTS for sponsoring this event. Let's bring Brennen. Welcome.
All right. Good morning, y'all. Can everyone hear me? No problem. All right. Well, as Melinda said, my name is Brennen Boze. I'm an attorney at the law offices of Carol Birch here in San Antonio. Melinda and Sheila, I know y'all started out talking about that handout I sent you this morning. I think that might be just a good thing to distribute, either during or after the presentation. It's what we give to new clients that are coming in for estate planning services. And it kind of lets you know what to expect. But for purposes of our presentation today, I think the most helpful thing is that at the end of the handout, there is a glossary of some of the legal terms we'll be discussing today. So that way you guys don't have to worry too much about, scrambling to take notes, things like that. I just wanted to give you something in writing that you could go back and refer to after we're done here today. Thank you for that introduction, Melinda. Today I'm going to be talking about the basics of estate planning, what it is, why it's important, and the things you need to do it properly. We will also have a brief discussion about the probate process and long-term care planning and how estate planning kind of interacts with those two concepts. We should have time after the presentation for questions and answers. So, feel free to save those for the end. If you're worried if you've got a question in the middle of this and don't want to forget it, feel free to put it in the chat box. And after the presentation, I'll go back and make sure and circle up and get you an answer to the question. So with that, I will go ahead and get my, it's not letting me do screen sharing, Melinda, for the PowerPoint.
Sheila, share screen. Let's see.
Got it.
There you go.
Okay, good deal. All right, can everyone see that now? All right. Well, like I said, I'm an attorney with the law offices of Carol Birch. We are something of a niche firm. We focus in what is called elder law. Like the name sounds, elder law is focused on the needs of seniors, persons with disabilities, and their families. You may note that there's not a ton of elder law lawyers out there. This is a relatively new area of the law. It kind of became big in the 1990s with the baby boomers, which was the largest generation in American history, of course, becoming seniors, and then just the large growing elder population. People are living longer these days, and there's a large need for these type of services that aren't otherwise addressed in a lot of law firms. So the areas of focus that we do here at the law offices of Carol Birch are estate planning, probate services, we do guardianship, and then we help people with long-term care planning and Medicaid eligibility for long-term care needs. And again, we'll kind of go through this throughout the presentation today, but this is just kind of the bird's eye view of what we'll be discussing. All right, so estate planning, some misconceptions about it, and kind of why it's important. Estate planning is more than simply deciding who gets my stuff when I'm gone. It is called estate planning. That's what we refer to it to. And a lot of people come in to us saying, you know, I'm just a regular Joe. I don't have an estate, but estate planning is not just for the wealthy. The issues that are involved in estate planning and that estate planning can take care of for you affect everyone, regardless of your station in life or your financial situation. The biggest things it can do is ensure that you, and more importantly, your family, are cared for in case that you become incapacitated or disabled. When you pass away, it helps you protect your hard-earned assets and make sure that the wishes you have for those assets are enforced by the laws of Texas. In addition to that, it allows you to make provisions to care for minor children that you may have, or family members with special needs. Through the estate planning process, we can create particular types of trusts to care for minors who may inherit money from their parents or grandparents, or people with special needs that receive government benefits. There are special kinds of trusts that we can do that allow them to have money for their personal needs without endangering their government benefits that they rely on. Another huge benefit of estate planning is just avoiding family disputes. Like Melinda said, I was a litigator for 10 years, a trial lawyer basically, in Houston. I did a wide type of work, but most of it was defending businesses that had been sued in the personal injury context. So I am very familiar with the fights that go on over money and business disputes, personal injury disputes. But I will tell you that there is sadly nothing nastier than a family that cannot get along after someone has passed away and are fighting over their inheritance. So good estate planning can help you avoid that. Make sure that everything is taken care of, that there is a plan in place for every possible contingency, and kind of cut off at the pass anybody who might kind of try to come in and contest what you have put in place. And finally, estate planning helps ease both the financial and the emotional burden on your family. It can take some of these very difficult decisions about medical treatment or financial matters outside of their hands in a time where they are grieving and they have a lot on their plate. Having your estate planning documents in order can go a long way towards giving them peace of mind and knowing that, you know, this stuff is taken care of and there is a plan in place. We just have to let the process work itself out. So some of the key documents involved in estate planning that I'm sure many of you are familiar with, but I will go through today and talk about in detail. The first and the most important is a will, of course. Most people are familiar with that. And then trusts, which, you know, is kind of a murkier area for most people. And I'll talk about kind of the interplay between wills and trusts and what may be right for you in your particular situation. After that is a financial power of attorney. In Texas, that's called the statutory durable power of attorney. In addition, you also need a medical power of attorney. As they sound like, the financial power of attorney is designating someone to handle your finances for you. The medical power of attorney is a separate document that is required to appoint someone to help you make medical decisions in the event that you're not able to. In addition to those, we have advanced directives. Many people have strong feelings about end-of-life care and treatment, artificial life support, and things like that. This is a way to help you plan for that. A HIPAA authorization is also something that you need to have in place. This is what gives your family members or the people that you designate access to your medical records and allows your healthcare professionals to speak to them to help you make treatment decisions when the time comes. Finally, we prepare declarations of guardian for people. That's both for guardians of minor children that you may be taking care of, or a guardian for yourself in case of incapacity. And again, through this presentation, I'm going to go through each of these documents one by one and give you a more thorough explanation, but this is kind of the universe of documents that we'll be talking about today. So first up is the will, and most everyone knows what a will is. That's a document where you get to tell the world, you know, when I'm gone, here's who I want my belongings and my assets to pass to. A will is also important because it allows you to name an executor of your estate. That is the person that is going to be representing your estate in the probate process. They'll be in charge of making sure that all your debts are paid and that your assets are distributed in the way that you want it to be in the will. Now, what if you don't have a will? If you don't have a will and you haven't done other estate planning techniques to avoid probate, which again we'll get into further on in this presentation, you will be subject to what are called the laws of intestacy. The laws of intestacy are just a framework set up by the state of Texas to say that if someone passes away without a will, here's how their assets are distributed. It, will pass to children or surviving spouses. It's a complex distribution schedule. It's a little outside the scope of what we're talking about here today to get into the details of that. But the biggest thing to remember is that if you don't have a will, there may be some unintended consequences. It may go to family members that you did not want to have your assets go to. Or if you had stepchildren that you raised as your own, the law may not recognize them in the intestacy statutes. And so they may be shut out of inheriting from you. So a will, of course, is a very important document to make sure that, your wishes are enforced after you are gone. Now, one of the biggest misconceptions that we see about wills are someone will come into our office and talk about estate planning and, they'll say, oh, and yeah, I own this piece of property that my dad left me in his will. And we go back, of course, and we look in the deed records to make sure that everything is in place. And the property that they're talking about is still in their deceased dad's name. That is because wills do not take effect automatically. A lot of people are surprised to hear that. But with a will, you have to submit it to a probate court for approval. And the probate court will oversee the distribution of your estate. Now, if you don't have a will, you still have to go to probate court. So this is not a situation where you can say, aha, I'm going to get around the process by just not having a will. Your family is still going to have to go to probate court, but it's going to be significantly more complex, time-consuming, and expensive to do the probate process when there's not a will in place as opposed to when there is. So one of the things that we stress to people, there are a lot of services out there that offer online wills. You just fill in some blanks and they will prepare a will for you. Many of them will say that they are, specific to each state, and some of them may be. But I always tell clients to be aware of that, because if your will does not meet the standards that Texas requires for a valid will, it will just simply be disregarded, and your estate will be subject to the laws of intestacy, like we talked about before. And that's when those unintended consequences come into play. So for Texas, the main requirements are that the will must be in writing. It must be signed by the testator, and there must be 2 witnesses that sign the will as well. One of the things, if you go to an attorney, that they will do is make sure that the will is what is called self-proved. If it is self-proved, then when you go to probate court, you do not have to hunt down those witnesses that may have signed your will 20 years ago and bring them into court to testify. The will is allowed to stand on its own. Without that self-proving affidavit, you're stuck with going and finding those witnesses wherever they may be. And a lot of times that's a difficult process. So, the long and short of it is there are lots of options for creating your will. Just be very aware, do your research before you do this, and make sure that the will that you have is going to comply with Texas law and is going to be enforceable and is not going to create additional hurdles for you and your family after you're gone. Now, a will pass the majority of your assets upon your death. But there are some assets called non-probate assets that pass outside the will. The biggest examples of this that we see regularly are, for example, life insurance. When you take out a life insurance policy, they will almost always ask you to designate a beneficiary. That beneficiary designation supersedes whatever you say in the will. The beneficiary designation is a contract with the life insurance company or the financial institution that says that upon my death, the assets that are held by this company will pass to the person I designate. It's not just life insurance. You can set this up for your bank accounts, your IRAs, your 401ks, and your brokerage accounts for investments. So there are a lot of ways that you can pass assets outside of a will to allow your family to access those assets immediately without going through the hoops of probate court. That said, even if you do that, there are likely going to be assets such as your house, your car, things of that nature that are still going to need to be probated. Another way to pass assets outside of probate is what is known as a ladybird deed. And that is a way to pass your house or real property that you own at your death in a way that goes outside of the probate process. If you have questions about these kind of ways to avoid probate, I'm happy to talk with you about them at any time. I'll give you my contact information at the end of the day. Never hesitate to reach out to me. I'm happy to discuss this stuff with you. Another question I get a lot of times is about trusts versus wills. A trust is a different vehicle. A trust is a way to pass your assets. It's a special relationship you set up where you designate someone to be in charge of assets that you then place inside of a trust. And what placing an asset inside of a trust means is that you actually go and transfer the deed to your house from you personally to the name of the trust you set up. Trusts have a lot of benefits, and there are lots of different types of trusts. Like I mentioned earlier, there are trusts specifically for people with special needs that allow them to maintain their government benefits while still having some extra money come in. There are trusts that are for minor children who inherit. But a lot of people know of what is called of a revocable living trust. And a lot of lawyers will offer that to people as a way to avoid the probate process. The thing to know about that is that it can be extremely handy for people with large estates, or if you have land in multiple states that would require multiple probate proceedings. It can save you a lot of hassle. But for the average person that has a house, some bank accounts, and maybe a retirement account, a trust might not necessarily be the best vehicle for you, because it does require a lot of work on the front end for you to do during your lifetime to make sure that everything is put into the trust. And if you leave even one asset outside of the trust, then you have to still go back to probate court. And you kind of lose the benefit of what the trust was designed to do, which is avoid probate. So again, it really depends on your unique situation. But a trust, just don't ever go in thinking that a trust is a one-size-fits-all document. It requires a lot of work. It's a complex scheme to set up, and you need the help of an attorney to do that. We can set up trusts within your will, though. And that is particularly helpful in the situations where I described, where you may have a child with special needs or a minor child that would inherit. The trusts set up within the will are less complex, but still allow you to designate someone to handle that money and be in charge of it for the benefit of the minor child or the person with special needs, so that you don't have a 14-year-old kid just coming into $100,000 and they don't know how to handle it responsibly. Finally, one of the other big questions I get from clients is about the estate tax. Many people are worried about that a lot of their children's inheritance is going to go to the government when they die. The biggest thing to know about the estate tax is that it only applies if your probate estate is greater than, in 2021, $11.7 million. So if you have less than $11.5 million, you do not need to worry about the estate tax. There are discussions out there. There is talk that estate tax exemption may eventually be lowered from $11 million to $5 or $6 million. If you're getting close to those numbers, if you have a large investment account that is close to that, a trust may be advisable for you, because there are ways that we can minimize your estate tax exposure. But for the vast majority of people that come in, I want to give them the relief that when their children inherit from them, that inheritance is largely tax-free, so long as you're under that $11.7 million estate tax exemption. Okay, so the next major document that we want to have in place for all of our clients is a financial power of attorney. In Texas, that is known as a statutory durable power of attorney. It's statutory because there is a specific Texas statute that authorizes and sets out how the power of attorney should operate. It is called a durable power of attorney because it endures even after you become incapacitated. And in fact, that's the main benefit of it, is to have someone ready to step in should something happen to you where you're no longer able to manage your own finances. So what the power of attorney does is allow you to appoint someone to handle those finances in case of incapacity. One of the things I counsel my clients about regularly is that they say, I have 3 children and I want to name all of them my power of attorney because I don't want it to seem unfair. That's okay to do, and the law allows you to do that. But I just want folks to go in with eyes open. When you name multiple powers of attorney, what's known as co-agents, a lot of times they are required to always be in agreement before they can do something. And so if there is any dispute between them, it may tie up your finances in a way you don't want. I personally think it's better to pick one person to handle it, so that way there is no conflict between your agents. And again, designating someone under a power of attorney is giving them a job, really. It's not a gift you're giving your children. You're giving them quite a bit of responsibility. So no one should feel that they have been left out just because they're not the primary power of attorney. Another thing to note about powers of attorney is that it does not take away any rights from you. It only gives powers to people. So when you sign a power of an attorney, you are not giving your agent the right to handle all of your affairs, and now it's outside of your hands. You continue handling your finances up to the point that either you no longer feel comfortable with it, or a doctor has declared you incapacitated. Now, the Texas statutory power of attorney form is fairly lengthy, and it requires you to make several choices throughout there. Several of those choices can affect long-term care planning. And when I say long-term care planning, I'm talking about the need for nursing home care eventually. That is, of course, a very expensive proposition for a lot of families. They may have to rely on Medicaid. And the way you set up your financial power of attorney, if you do it with an attorney who gives you proper guidance, can help give your agent the flexibility to do some long-term care planning for you in a way that gets you the care you need while also preserving some inheritance for your loved ones. Now, a financial power of attorney is usually effective immediately. We do it that way for a very specific reason, and it's because otherwise, if you don't make it effective immediately, it only takes effect if a doctor declares you incapacitated in writing. And for many people, that, it may take a long time to get to the doctor. You may be having a good day during that doctor's visit, and he may say, well, you're not incapacitated. But you and your family still realize that you need somebody to step in here. So it just creates an additional hurdle that may not be necessary. So we make our powers of attorney effective immediately for that reason, so that your family doesn't have to go through the hurdle of setting up a doctor's appointment, getting you declared incapacitated in writing before someone is able to step in and handle your finances. Because of that, though, it requires a high degree of trust in the person that you are naming your agent. Because once you sign that power of attorney and you give your agent a copy, they are able to go to the bank that day and start, managing your finances for you. You can do it yourself as well, but then you've got two people competing. So when you name your financial power of attorney, it's very important to make sure you have a high degree of trust in that person that you name. So what happens if you don't have a financial power of attorney in place and you become incapacitated? Most likely, your family is going to be locked out of your bank accounts. They're not going to be able to sell assets for you to help you pay for care. They're not going to have the flexibility needed to help spend down your assets to get you qualified for Medicaid if you need to. It just ties up your finances in a way that makes it extremely difficult for your family and may require them to have to spend their own money, even though your money is sitting there just waiting for you. No one's just able to access it because that power of attorney hasn't been put in place. The next document we do is a medical power of attorney. It's exactly what it sounds like. You designate someone to step in the case of your incapacity to help make medical treatment decisions for you if you're not able to. Now, unlike the financial power of attorney, the medical power of attorney only becomes effective when the doctor certifies that you're incapacitated. And, that's very important, because so long as you have the ability to communicate your desires and the soundness of mind to make your own treatment decisions, you should have the right to make those decisions for yourself. That's a very personal thing, and it should only be passed to someone else if you are personally unable to do it. So it's a little bit different than the financial power of attorney in that respect. Along with the medical power of attorney, like I said at the beginning, we do a HIPAA authorization for the people that you have listed in your power of attorney. That way they are able to talk to your doctors and see your medical records to help you make treatment decisions in the event that you become incapacitated. Without that HIPAA authorization, HIPAA, which is a law, it's been in the news a lot lately, I'm sure you've heard of it. What that law does is protect your privacy for medical records. HIPAA prevents your doctors from giving your medical information to anyone unless you have specifically authorized it. So a HIPAA authorization is a key document that you need in place, so that way your family has access to the information that they need to make sure that you're getting the care that you need. The next document that we do is known as a directive to physicians. Some people know of it as an advance directive or a living will. This document allows you to make end-of-life treatment decisions. Now, this only comes into play in very limited circumstances. So first of all, you have to be declared incapacitated. You're in a position to where you're not able to make decisions for yourself. But in addition to that, you have to be suffering from either a terminal condition or an irreversible condition. And in those situations, it allows you to tell your doctor or your healthcare provider in advance whether or not you want things like artificial life support, whether you want to be on a ventilator or a feeding tube. Many people have strong feelings about that. They say, I don't want to be hooked up to machines that prolong my life unnecessarily. Other people feel the exact opposite, that, if there's a way to keep me going, I want whatever treatment is necessary to keep me alive as long as possible. This document allows you to tell your doctor in advance what your decision would be in those circumstances. And the real value of that is to take that burden away from your family, because that is, of course, a very difficult decision to leave to your family members, whether or not to continue or discontinue life support. So having a directive to physicians in place takes that burden off of your family. They can feel confident knowing, this is what mom or dad had put in place. They had thought this through, and in this circumstance, this is what they wanted. So, I think that's a very important one to have if you have strong feelings about artificial life support and end-of-life treatment. I backed up. Let me back up here. Okay, so here we go. Is everyone still able to see my screen?
Sheila.
No, we can't.
Okay, let me make sure that that's back up. How about now? Okay,
Yes.
Good deal. All right, so the next one up is a declaration of guardian. Now, guardianship proceedings are an extraordinary thing to do. It is a kind of a backup to the powers of attorney, is the way I explain it to a lot of my clients. And there's two real types of declarations of guardians that we can do. The one most people are familiar with is a declaration of guardian for minor children. So if you have a young child that you are responsible for, the declaration of guardian allows you to tell the court, if something happens to me, and guardianship is necessary for this minor child. These are the folks that I would like to be in charge of A, taking care of the minor personally and their personal well-being, and B, taking care of the finances for that minor child. Now, we also have a declaration of guardian that applies for you personally, the client, in the case of incapacity. Now, we always hope that your powers of attorney are there to give someone the ability to step in and take charge of both your medical decisions and your financial decisions, and it will allow them to do that. But there are many situations, unfortunately, where someone either, because of dementia or Alzheimer's, either is undoing the things that their power of attorney is trying to do. They are sending money to scam artists and things like that, or they are, wandering. They are leaving the house and are a danger to themselves and others. And in those extraordinary circumstances, guardianship proceedings may be necessary. The guardianship proceedings are extraordinary because, unlike the powers of attorney, like I said, the powers of attorney doesn't take any rights away from you. But in a guardianship, the ward, who is the person that the guardianship is over, the ward loses rights. They lose the right to have a driver's license or to manage their finances. It's a way to protect them from themselves. So there are two types of guardianship. There is guardian of the person, and that is you are able to designate the people that you would want to be in charge of taking care of you personally and looking out for your health and well-being. And also a guardian of the estate, which is similar to the financial power of attorney, someone to step in and handle your finances for you. Those can be the same people, or you can have separate people, one for guardian of the person and a different person for guardian of the estate. It allows you some flexibility, but this document allows you to tell the court, while you're still of sound mind, that if these extraordinary proceedings are ever necessary for my benefit, these are the people that I want in charge and taking care of me. Otherwise, if you don't have that in place, it can lead to, again, conflicts among family members. Your children may have very different feelings about how you should be taken care of. This allows you to make that decision so that there is not a conflict between your loved ones in the event that this becomes necessary. The final document that we do is called an appointment for disposition of remains. The way I like to explain this to people is it's a burial power of attorney. Financial powers of attorney and medical powers of attorney, they cease to be effective at your death. So if you pass away, your agent under the financial power of attorney can no longer go to the bank and keep paying your bills under that power of attorney. It loses its effect. The burial power of attorney, the appointment for dispositions of remains, it survives when the others do not. So what it allows you to do is designate one person to be in charge of either making or carrying out your burial and funeral arrangements. This document is especially important in Texas if you have a desire to be cremated. Texas, if you don't have this in place, defaults to burial. If you don't have specific instructions otherwise, the state of Texas says that you will not be cremated unless all of your heirs sign off agreeing to that. So if you've got one child that has strong feelings, that they don't want cremation, they can tie up the process if you don't have this in place. This allows you to just designate one person to be in charge of taking care of this. Again, it avoids conflict. It makes your wishes known in advance, and it gives that person the legal authority to carry out the wishes that you had. One thing I always warn people about with this kind of document, though, is that the agent that you designate to be in charge actually assumes financial responsibility for the burial and funeral costs. So it's important, if you're able to make arrangements early, to buy a prepaid burial plot or prepaid funeral arrangements, and make sure that your agent under the appointment for disposition of remains knows what those are and how to contact those people. So one of the big things to do with all of these documents is make sure that the people that you are designating understand and know what your particular wishes are, because they're going to be the ones making these decisions. Okay, so moving on, I'd like to just talk briefly, if we've got time, about the probate process. The probate process is just the legal procedure for making sure that a deceased person's assets are properly transferred and that any debts that they have at the time of their death are paid. Now, if you have a will, the probate process is fairly simple. It does require court proceedings, and it does require your family to hire an attorney, but it is not particularly involved. The lawyer will handle the vast majority of the probate process for you. You would just have to appear for a short hearing. Usually that can be done by Zoom like we're doing today. You can appear remotely, so you don't have to go down to the courthouse. And then otherwise, the executor that you designate in your will gets appointed by the court and gets the legal authority to pay your debts and distribute your assets according to the will. Now, the biggest thing to know about this is that you need to apply for probate within 4 years after someone passes away. After 4 years, the will no longer be honored, and you're stuck with going by the laws of intestacy, and we're back to those potential unintended consequences. So if you don't have a will, the state of Texas decides who gets your stuff. And in addition to that, the probate procedure is much more complex. The court must determine who your heirs at law are, and that is determined based on your marital status, your children, whether or not you have a blended family with, stepchildren. And part of the process is that the court is going to appoint a separate attorney whose whole job is just to investigate whether or not there are additional heirs out there. Of course, this is a separate attorney. The estate is responsible for paying for that separate attorney. And again, it just makes the probate process much more difficult. So we try to stress the importance of having a will to all of our clients. Now, what if I do nothing? What if I never take the will to probate court? First of all, after 4 years, you're stuck with the intestacy statutes. But more importantly, at your death, most likely, if you have not designated beneficiaries on your accounts or set up transfer on death deeds, things of that nature, your family members are going to be locked out of all of your assets. They're not going to be able to access your bank accounts or your retirement accounts to distribute that money to anyone. They're not going to be able to sell your house or your real estate. Now, there are alternatives to a full probate, but they only apply in very limited situations. There are things called small estate affidavits, where if your entire estate is under $75,000, the process is somewhat simplified. There are other things like probating a will as a muniment of title or doing affidavits of heirship that are simpler, but are much more limited. And again, they don't give you the benefit of directing how you want things to go in a will. And it just leads to a lot of unintended consequences. There are ways to avoid probate altogether, like we have talked about, but they require some detailed estate planning that is kind of outside the scope of what we can talk about here today. Finally, the last thing we do here at our office is long-term care planning. That is usually when someone requires 24-hour nursing care. It's something, no one wants to think about that, but many of us will eventually need. Long-term care costs are incredibly expensive and are going up every year. For a private pay nursing home in the San Antonio area, it's not uncommon to cost between $5,000 and $8,000 a month. Many people think that they have private health insurance or Medicare, and that's going to take care of their nursing home costs. But nursing home care is not covered either by regular health care, health insurance, or Medicare. Medicaid does pay for nursing home care, but they have very strict income and resource limits. So you must spend down everything that you own to get to basically a poverty level before you can apply for Medicaid. There are long-term care planning strategies that we can do to maximize your inheritance for your children and preserve as many assets as possible while still getting you qualified for Medicaid. But it's something to consider. And the other big downside to Medicaid is what is called MERP, the Medicaid Estate Recovery Program. So if you apply for long-term care Medicaid and Medicaid pays your nursing home costs, when you pass away, MERP is the recovery program. They will file a claim against your estate and recover the costs that they spent on your care. And normally that comes out of the person's biggest asset, their home. So a lot of times the loved ones are forced to sell the home just to pay the Medicaid recovery costs. Now, again, we can avoid Medicaid recovery, but it requires detailed estate planning. So what are your options? You can get long-term care insurance, but that's also very expensive. And you may be outside the age where it's available to you. The other option is to spend all your money down until you qualify for Medicaid, but then you have no inheritance to leave your loved ones. So what we try to stress to people is proactively plan for long-term care or Medicaid eligibility. There are things like a qualified income trust, ladybird deeds, special types of annuities, and gifting strategies that we can use to get you qualified for Medicaid while still preserving some inheritance for your loved ones. Okay, so it is now 12:25. I've gone a little longer than I expected, but if anybody has any questions, I'm happy to answer them.
Yes, Brennen, wonderful presentation, and I learned a lot. My question is, I heard that the state of Texas is looking at changing the look back period for Medicaid. Is that true? Like from 5 years to 10 years?
Okay, that has been discussed. It is not the law yet, and there's not a law pending to extend that look back period. But what Melinda is talking about is that when you apply for Medicaid, you have to give them all of your financial information, bank statements, lists of all your assets, things like that. And so sometimes people anticipating the need for Medicaid will try to give away their assets during their lifetime to their loved ones. Medicaid has what's called a look back provision, and they go back 5 years. And if you have made any sizable gifts in those 5 years, and by sizable, I mean over about $200. So if you try to deed your house to your child during your lifetime, Medicaid is going to penalize you for that. And they're going to say, well, if you had the money to make gifts, you don't need our services. So they will impose what's called a penalty period during which you are going to be ineligible for Medicaid services. And that penalty period is going to be based on the size of the gift. So if you give your grandson $1,000, that may make you ineligible for a month. But if you give your house away and it's a $300,000 house, that could make you ineligible for Medicaid for years and cause a lot of problems. So that's just something to be aware of. The thing we stress is be proactive with estate planning. Do this stuff before the need arises, so that way there's a plan in place and you've got your affairs in order to make sure that when you do need this, you're not going to be locked out of the care you need. So Melinda, I hope that answers your question.
Yes, thank you. And I got one more. What is the poverty level, the amount monthly for Medicaid application here in the state of Texas? I mean,
in the state of Texas, they're going to look at two things: your monthly income and what's called your resources, which are your assets. Now, your monthly income has to be below $2,382 this year. Again, there are ways we can get you under that limit. There's a special kind of trust we can do. So if you have more than that coming in from retirement income, that's not going to prohibit you from qualifying for Medicaid. We're just going to have to jump through some extra hoops. The other thing that they look at is resources, your assets. Now, Medicaid does not count one house. So if you have your homestead, they're not going to count the value of that homestead against you. But, and then you can also have one vehicle, and certain retirement accounts are exempt. But other than those things, you cannot have more than $2,000. That means your savings account has to be below $2,000. Your checking account has to be below $2,000. You can't own multiple properties. You can't own multiple vehicles, or those are all going to be things that push you above the Medicaid eligibility limit and disqualify you from Medicaid.
okay, thank you.
And Brennan, on that $2,000, just to clarify, that is in total, correct? And it's not per account.
For income, that's well, no, yes. The resource limit is $2,000 across the board. Again, your house, one house is exempt and one car is exempt. Everything else that you own must total less than $2,000 to qualify. So, you know, these long-term care strategies, planning strategies are really important, because lots of people could qualify for Medicaid benefits that really need them. But if they don't proactively plan, they get locked out of these benefits, and it causes a huge burden on that person and their family.
Okay. Sheila, we have questions in chat. Do you want to go ahead and?
Yes. So we have one question: that what is the cost of setting up all these items?
Okay. Our office, we lots of attorneys charge by the hour. And we do for some services, but for estate planning purposes, we offer different types of packages based on what you need. To set up a will and all of the other documents that we discussed today, and including special kinds of trusts in the will, we charge $1,500 for that. If you and your spouse come in and both do your estate planning at the same time, it's $2,250 for all of those documents for each of you. If you just need powers of attorney and the other estate planning documents, but you already have a will, for example, it is $750.
Okay, and what she says, what about spouse income? Now, I'm guessing that's meaning for Medicaid.
I will assume that that is, yes. Okay. So spousal income complicates the Medicaid calculus considerably. It's a little more complex than we really have time to go into. But what they will do is, if you have a spouse that does not need nursing home care and one that does, Medicaid allows the non-institutionalized spouse the ability to set aside some additional income and resources. they're going to not look at your spouse's income, and your spouse is going to get the benefit of some of your assets that would avoid getting you, that could get you below that $2,000 threshold while still making sure your spouse is taken care of. So you're not just stuck if one spouse makes too much money, but the other one needs nursing home care. There are ways we can preserve the spouse's income and some of the spouse's resources while still getting the spouse that needs the long-term care the help they need.
Okay, and Brennan, this is from me. I was told that to prevent any family fighting or disgruntledness about a will, to always keep your most current copy of your will with your doctor in your medical records, because nobody can get to that, and as long as it's the most current, that would be the safest. What is that good?
To be honest, I don't know that I would advise that. If you have a long-time doctor that is willing to keep the original will, and you have a lot of trust in them, and they're not about to retire in the next 5 years or anything like that, then maybe that's an option. What I try to stress to people is, and I didn't mention this at the beginning, in the probate process, the original will is very important. If you have a copy of a will, you have to jump through a bunch of extra hoops to get it approved by the court. So you need to keep the original very safe. I try to get my clients to make sure that they put it in a fireproof safe or a fireproof lockbox, or maybe even a safe deposit box. The thing to remember with a safe deposit box, though, is that you want to make sure that your executor that's named in the will also is listed as being able to access the safe deposit box, because you don't want to get them locked out of it and they're not able to get to the original will that they need to qualify you for probate. So the biggest thing is just someplace where your family knows where to find it, where it's protected from, burglary or fire, but leaving it with someone else is playing a dangerous game, because you never know what could happen. Your doctor could retire and close up his practice. He may not remember that he has your will and just may shut everything down, and it's impossible to find the original. If you've got a doctor that you know is going to be around for a long time, you've had a long-term relationship with them, and you discuss this with them, maybe that would work for you. But I don't know that that's a one-size-fits-all solution.
Are wills recorded at the county that you reside in, or any county?
No, you can in Bexar County. They will charge for a very small fee. You can store the will at the courthouse. They have a repository where they will keep the original. So that way, when you need it, you know exactly where to go, and it's right there. But it is not, recorded like a deed would be. Now, when you apply for probate after you're gone, the will is filed with the court, and it is a public record at that point. So it is not, as soon as you sign the will, you don't go take it down to the county deed records and have it recorded as a public record. But eventually the will be need to submit to the probate court. And at that point, it is somewhat public. There are provisions to maintain privacy, but it does have to be given to the court.
Okay, and if someone was to come to you and have all this done, do you guys keep records of that?
What we always do is we have a signing conference where you come in and sign all the documents. We have the witnesses there for you, and we notarize everything. And then we'll take all the signed documents and scan them into our system. So that way, if something ever happens to them, you've always got them with us. But we're not in the habit of keeping originals for people for the same reasons I discussed. It may not be a good idea for a doctor because something could happen. The lawyer may close up their practice. they may die and their staff may not know where everything is. It's better for you to know exactly where it is and your loved ones to be able to access it immediately when the time comes.
So Sheila, to answer that question, we gone through Carol Birch, group for my in-laws. So they do keep a copy. So I've been just calling Carol Birch office and then they provide us with copies.
Yeah, we will always give you a copy if you need it, for sure.
Yes.
And the powers of attorney is not like a will. The powers of attorney, a copy is just as good as the original.
Yeah.
A bank should honor a copy of a power of attorney. So if something happens to those, we can get that to you, quickly and easily.
That's right. So guys, it's 12:38. So Sheila, I know there's a lot more questions in chat. How do you want to handle that?
It's up to Brennan, if he has time to answer a few more.
How many more?
There's not too many more.
Okay, I'm looking at the chat now. I see one from Kim. What is the cost to look over the documents and make amendments to the trust for both my spouse and me? Well, for just a consultation, if you need us to look at your documents and say, hey, these are still good under Texas law, or you moved from another state and you have estate planning documents from another state, we're happy to take a look at those and tell you if these will work fine, or you need to make X, Y, and Z changes. We will just charge hourly for those consultations. If you go with Carol Birch, the partner here, she charges $3.25 an hour. These consultations usually last about an hour. And then for me, it's $2.75 an hour. So, and then if we end up needing to make changes or amendments to the trust, that hourly fee will just be rolled into the cost of what we end up doing, if necessary.
So
And is power of attorney able to be accessed over the phone?
No. Most of the time, each financial institution is got their own requirements. Some are bigger sticklers than others, but across the board, they are going to want a signed, notarized copy of that power of attorney that they can keep in their files once it's used. So that way they can say, oh, child A has been named power of attorney and they have the authority to access this account. Doing it by phone, I don't think that there's any financial institution out there that would just kind of take your word for it without seeing the actual document.
And another question, is it different from state to state on the amount of time you have to process after your loved one has passed?
Yes, every state's laws are different. Most of them roughly line up, but each of them has their own idiosyncrasies. I am licensed in Texas and Arkansas, but beyond that, I can't really speak to what other states' requirements are outside of Texas. What I can do, though, is if you've moved from, say, California, take a look at your will and tell you, hey, this is perfectly fine. A Texas court will honor this will just like a California court would. You don't need to make any changes, or here's what's wrong as under Texas law, and here's what we need to do to make it right.
What is that time frame for Texas?
The time frame for
to once the loved one has passed, to get all the distributions and everything done.
Okay, so you have 4 years after the person dies to initiate the probate process. The probate process, depending on if there is somebody coming forward to contest the will, or if you've got a big creditor that files a claim, it can extend it, but usually the whole process is wrapped up in 4 to 6 months. So most of the time, after the executor files an inventory of all of the estate assets and the court approves that inventory, we want to give a little bit of time to make sure that no creditors are coming forward. They have 4 months generally. And then after that point, it's fine to go ahead and distribute everything.
Okay. And let's see.
There's one, Sheila, on advanced directive. So I just want to let you know, advanced directive, but there's, if they do not want CPR, there is another document called out of hospital, the DNR, that needs to be done. Is that correct, Brennan?
Right. A DNR is different than an advanced directive. An advanced directive is while you are living, deciding what kind of artificial life support you want or don't want. A DNR is a doctor order, a doctor's order. So you need to fill that out with your healthcare professional. And unlike the advanced directive, the DNR only applies if you have legally died. It's whether or not you want them to take efforts to resuscitate you using CPR or a defibrillator, things of that nature. So it's in the same ballpark as an advanced directive, but they serve two different purposes. And one is a legal document, the other is a medical order.
Okay.
What is the difference between the Ladybird and the Todd?
That is a very nuanced, difficult question. A Ladybird deed and a Todd is a transfer on death deed. What both of those allow you to do is designate during your lifetime that at my death, I want this piece of property to pass to these people. A Ladybird deed, and in both cases, the owner of the land or the house retains the right to revoke that deed and do whatever they want during their lifetime. So it's not actually a gift that takes effect until you have passed away. It's very important for Medicaid planning purposes. A Ladybird deed can, again, avoid estate recovery because it passes the land outside of probate. And if it's not part of the probate estate, then the Medicaid recovery program can't claim against it in the probate process. So it's a way to move it outside of that, make sure that the transfer happens automatically and preserve it from Medicaid recovery. The Ladybird deed has been around for a long time. It is a creation of what's called common law. Lots of title companies and financial institutions are more comfortable with the Ladybird deed than a transfer on death deed. A transfer on death deed is more recent. It has only been authorized by the Texas legislature in the last couple of years, and a lot of title companies aren't as familiar with it. They should honor it, but you may have extra hoops to jump through. The biggest benefit of a Ladybird deed is that it can be signed by your power of attorney. A transfer on death deed or a Todd cannot. So if it is a situation where you have become incapacitated and your family is coming to us to say, what can we do to protect mom's house? With a Ladybird deed, the person designated in the power of attorney can do that deed on behalf of the incapacitated person. But with a transfer on death deed, it's got to be the person themselves that owns the land. And if they don't have capacity anymore, they can't do the deed.
And one more is if you have assigned a beneficiary or a director of your estate and something happens to them, when you create these forms, do you have like a backup? Or?
We always stress to have at least 2 backups for every person that we designate in all of these documents, whether that's your executor, whether that's a trustee, whether that's a medical or a financial power of attorney. We always want backups because our job is to plan for the worst case scenario, to make sure that no matter what happens, somebody is there to step in and handle this. That's something that we stress with our clients a lot is making sure that there are alternates in place.
Okay, and if somebody wants to get in touch with you, would they email you? What's the best way, or call?
Yeah, feel free to email me. I think my email is up on the screen. It's bboze, and Boze is with a Z, at assistingseniors.com. And I'm happy to answer any questions I can, or if we need to get you set up for a consultation, happy to do that too.